The concept of the jury system was imported into Britain after the Norman conquest, although its early functions were quite different from those today. Early jurors in England acted as witnesses, providing sources of information on local affairs, but they gradually came to be used as adjudicators in both civil and criminal disputes. Under Henry II, the jury began to take on an important function, moving on from reporting on events they knew about to deliberating on evidence produced by the parties involved in the dispute. Gradually, it became accepted that a juror should know as little as possible about the facts of the case before the trial, and which is the position today. The jury is considered as a fundamental part of the English legal system, although only a minority of the cases is tried by the jury in these days. In a sense, it plays a vital role in ensuring that the criminal justice system works for the benefit of the public rather than for the benefit of unjust leaders. It promotes not only a healthy criminal justice system but also a healthy society where political leaders cannot abuse criminal justice system to silence their opponents. Jury plays a vital role in the criminal justice system in England and Wales and many other countries in the world. But the constitutional position of the English jury is vulnerable because of the unwritten constitution. In England, because of the unwritten constitution, the right to trial by jury is not contained in the constitution. Generally, it is governed by the Act of Parliament, which can be amended by the Parliament anytime. So, the government of the day could alter or even abolish the right to jury trial. However, due to political barriers, the government is very cautious in doing this. The Juries Act 1974 is the main statute governing the present-day jury. Currently, the role of the English jury is almost entirely limited to the more serious criminal cases, but juries occasionally sit in civil trials as well. The function of the jury is to weigh up the evidence and to decide what the true facts of the case are or what actually happened. The judges give the direction to the jury on the relevant law, which the jury has to apply to the facts of the case in order to reach a verdict. If it is a criminal case and the jury has given a verdict of guilty, then the judge will decide on appropriate sentence. In civil cases, the jury's function is to decide on how much money should be awarded in damages. Although the juries are very important in the criminal justice system, they actually deal only in a minority of the cases. Criminal offences are classified into three categories. Summary offences are the minor offences and are triable only in the magistrate's courts. This kind of offences is indictable only, which must be tried in the crown court. Between these two extremes, there is another type of offence known as triable either way. Such cases, as is clear from the name, can be tried either in the magistrate court or in the crown court. The majority of the criminal cases are summary only because they are less serious and commonly committed, and as a result, 95% of the cases are heard in the magistrate court, where the juries have no role. Out of the remaining 5% of the cases heard in the Crown Court, in majority of the cases, either defendant pleads guilty, so there is no need of a jury, or the judge directs the jury that law demands them to acquit the defendant. As a result, the juries actually decide only around 1% of the criminal cases. But on the other hand, this 1% amounts to 30,000 trials, and these are the most serious ones that come before the court. However, technological changes are beginning to cause problems, which might raise the question on how well the jury system can work in the 21st century. One of the disadvantages of the jury system is that it may be hard to find impartial jurors. There are times where cases are so widely publicized that it is hard to find people who have not already formed an opinion on the case. In addition, it is known that the jury is representative of the community. A drawback to this is that the jury by nature may have their own biasness. People from specific group may be more sympathetic to a defendant that is from the same group. Hence, it is difficult to determine what a good mix of jurors really should be. Moreover, there are times where jurors are being asked to rule a case that is out of their experience. The obvious question is whether or not the jury decision-making process reaches a fair and impartial verdict.
Over. Copy. Is it a black teenager? Okay. Oh, you! Freeze! Don't run!
In October 2014, a white Chicago police officer was charged for the murder of Laquan McDonald, a black teenager. In the footage that was released a year after, it was seen that Jason Van Dyke, the white police officer, was seen to be shooting Laquan McDonald not once, not twice, but 16 times. While police officers that are charged in court usually prefers their case to be heard by a trial judge, Jason Van Dyke opted for a jury. However, there seems to be a problem with this jury. It does not look like the population of Cook County where the shooting took place, because in Cook County, almost 1/3 of the population comprises of black people, whereas in this case, there is only one black juror present.
Your Honor, we have reached to a verdict where Jason Van Dyke is guilty for his second-degree murder against Malcolm McDonald.
In this case, although there was only one black juror present, the majority still came to a decision that Sir Jason Van Dyke was guilty. Hence, racial biasness was not evident in this case. Stereotypes can be thought of the mental representations that people have for members of a group. These mental representations typically exaggerate the differences between groups and minimize the differences of people within the same group. Indeed, some researchers argue that racism does exist in the criminal justice system in the form of police brutality, racial profiling, and the overrepresentation of minorities in prison. Defendants are seen as more likely to be guilty when they come from a social category that are stereotypically linked to the features of the particular crime that they are alleged to have committed. Judicial rhetoric holds that jurors should be metaphorically as white as paper, and that juries are to approach their task without any preconceived ideas and by reference to the evidence alone. This is not what actually happens. In the jury box, the juror's decision-making is influenced by his moral values, personal experiences, personality, beliefs, predispositions, and prejudice. One of the rationales for trial by jury is that the defendant's conduct is assessed according to local norms by 12 ordinary people whose outlooks have been molded by their diverse characters, histories, and lifestyles. The Court of Appeal recognizes that a juror may draw inspiration from his past. What the law does not want is for jurors to take extra evidential factors into account that are likely to cause injustice, such as reliance on racial stereotypes. For example, to dismiss self-defense because those with dark skins are believed to be inclined to aggression is unacceptable. Other dangerous but unfortunately all too common stereotypes include black people look too much the same, do not respect the law, and are sexually promiscuous. Muslims are terrorists, Jews are greedy, Asians are devious liars. An example of a case where racial prejudice is evident is the case of Regina and Mirza. This case involves the conviction of the appellant of indecent assault. After the trial, a member of the jury sent a letter to the defense counsel and the trial judge alleging racial prejudice by the jury. The defendant in this case was a Pakistani man that has resided in the UK for 13 years. An interpreter was used during the trial, and the judge gave a direction that no adverse inference should be made regarding the usage of the interpreter. However, the letter suggests that according to the jury, the interpreter was used as a devious ploy to help his case. In Sanda and United Kingdom, the court found a violation of Article 6 of the ECHR, the right to a free trial, during the trial of 2 Asian defendants. One member of the jury sent a note to the judge alleging that at least 2 other members of the juries were making racist jokes and remarks. On examination, there was evidence confirming of such remarks, although the juror concerned dismissed it as a joke. Nonetheless, the court considered that this is sufficient to give rise to legitimate doubt as to the impartiality of the jury. In a report published in 2003 by Hood and Shute on ethnic minority perceptions of the criminal courts, 778 ethnic minority defendants were interviewed. Nearly a third of those tried in the Crown Court complained of unfair treatment, and a minority related this to their ethnicity. In the case of black defendants, it was 1 in 5, and in the case of Asians, 1 in 8. 6 of the 30 black defendants thought that the jury was unsympathetic to or racially biased against them. A further 4, whose main concern was racially biased sentencing, also complained about jury prejudice. A victim may suffer racial prejudice at the hands of the jury, which may manifest itself as an unjust acquittal. Among the reported allegations of jury racial bias includes one case in which the jury acquitted two white Leeds United football players of a serious assault on an Asian. It is possible to know whether the cause was actually race-related. There is no reliable evidence that racial prejudice is a problem for victims. In summary, it is evident that racial stereotypes against certain races do occur among certain jurors. Accusation that a juror made racially biased statements about a defendant may require judges to break through the usual secrecy that surrounds jury deliberations, where we'll look further to see whether the jurors know about the improper conduct in the jury room.
My name is Lim Jia Zhe. Today I'm going to talk about, do the jurors know what to do if there is any improper conduct in the jury room? During the trial, the jurors should give close attention to the testimony and follow the court's instructions. The jurors must not talk about the case with others not on the jury, even their family, and must not read the case in the newspaper or internet. If there is any outsider attempt to talk with a juror about the case which he or she is sitting, the jurors should tell the person it is improper to discuss the case or receive any information outside the courtroom. After the judge has summed up the case, the court usher has to keep the jury in a jury room to prevent them from speaking to anyone else. A jury room is a private room adjacent to a courtroom where a trial jury discusses a case and reaches its verdict. The jury may send a note to the judge to ask the question of law or the jury may send a note to the judge to ask a question of law or for the judge to read to them a transcript of some of the evidence. If there is an improper conduct in the jury room, the jurors have the duty to report to the judge. They also have the duty to inform the judge if there is any outside communication or improper conduct directed at the jury by any person. This can be seen in the case of R. and Smith. One of the members of the jury wrote to the judge saying that other members were failing to discharge their duties properly. Juror misconduct means an improper or illegal behavior committed by jurors during trial, including discussing the case with outsiders, accepting bribes, or reviewing outside evidence. An example of juror misconduct mentioned in LT's article is a juror in Manchester who tweeted openly throughout a rape trial. She was found to be tweeting to her friends and asking them to poll whether they thought that the man being tried was guilty or not, whether he committed the rape or not. Juror substance abuse, also considered as juror misconduct. If a member of the jury was abusing drugs or alcohol in some way during their time as a juror, then it can reasonably be assumed that his or her judgment in making a decision about the case was impaired. Juror substance abuse is a major violation that could be a huge asset to an appeal. If an allegation of misconduct or impropriety is made during the trial, the judge has the duty to investigate. According to Ministry of Justice research series by Cherry Thomas, almost half of the 196 jurors at Winchester who had served on a jury said they either did not know or were uncertain what to do if something improper occurred in the jury room. Also, 67% of these jurors also felt that they should be given more information about how to conduct their deliberations. Furthermore, an even larger majority of these jurors, which was 82%, felt that it was correct that jurors should not be allowed to speak about what happens in the jury room. In 2004, the House of Lords addressed the extent to which Section 8 of the Contempt of Court Act 1981 prohibits judges from questioning jurors about deliberations when accusations of jury impropriety arise. The court reiterated the long-standing principle that only the trial judge is entitled to investigate issues affecting jury. The effect of this ruling is that unless jurors being concerned about improper jury conduct to the trial judge attention before a verdict is returned, it is very difficult for such claims to be investigated after the verdict.
Monopoly, Monopoly, are you around here? If you are around here, please move to winner. Monopoly, Monopoly, if you're around here, please tell me, is Yang the killer? If Yang is the killer, move to start.
Your Honor, she killed two of my girlfriend. Not one, you know.
Your Honor, I did not do such a thing. He's simply accusing me.
So, jury, what's your opinion?
Your Honor, we have come to a verdict where the defendant is guilty based on our analysis of Oijia.
The widespread use of internet is having an impact on the legal process. More specifically, everyday use of channels like Twitter, Facebook and Google are presenting challenges to the ideal fair trial, with some jury members using the channels to do more than simply announce or complain that they've been picked to do jury duty. But what's the problem with jury members using social media during a case? What impact can a few stray tweets have on our jury system? Traditionally, courts have sought to balance a number of potential conflicting rights and principles when governing trials. Social media use by jurors can damage the capacity of courts to maintain an appropriate balance between these rights and principles. Firstly, a video of Regina against Karakaya.
What do you think about the case just now? Do you think the defendant is guilty?
I think the defendant is guilty.
I have no idea.
Okay, here I have the document where I would like to share with you guys. Have a look at it. This is about the information of the defendant. Your Honor, we have reached to a verdict where the defendant is guilty.
Guys, you guys have made a mistake. This document was found in the jury room, and it contains information regarding the defendant. Hence, I have evidence to believe that you guys have biasness against the defendant. And I order a retrial. Video, it is shown that the juror had brought in notes from the internet and used it as reference before deciding the verdict. The appellant, Karakaya, appealed against his convictions after it emerged that a member of the jury had taken documents downloaded from the internet into the jury room during deliberations. Karakaya had been convicted of indecent assault and rape by majority verdicts. After the jury left the court, it was discovered that a juror had taken documents into the jury room during deliberations. Karakaya argued that the documents were inaccurate and included a number of points which the Crown could not have made either in evidence or in addressing the jury. The judge held that he will be allowing the appeal that the instant court was entitled to re-examine the documents, the downloading of the documents, and their use by the jury after they had retired well-established principles. The internet contained materials which could influence a juror's view. If used for research during a trial, it could just as easily influence a juror's mind as a discussion with a friend or neighbor. Verdicts given in such circumstances were not true verdicts, according to the evidence presented at trial. In the instant case, the documents obtained by the juror from the internet after the juror had retired contravened the principle which prohibited the use of privately obtained information, potentially relevant to the outcome of the case. It is also contravened the principle that the jury was not entitled to receive further material after they had retired. On that basis, Karakaya's conviction was unsafe. Therefore, his appeal was allowed and conviction was crushed. A retrial was ordered. The principle set out in this case notes that any material privately obtained or used by a juror whether before or after the jury retires to reach a verdict, contravene two basic tenets of the rule of law. The first concept is of open justice, in which not only the defendant but the public, and indeed anyone with responsibility for the trial outcome, is entitled to know exactly what evidence is being considered in the case. That includes the counsel, the judge, and any future court of appeal. By obtaining and considering material that hasn't been presented in the courtroom, the juror risks putting every representative in the trial at a disadvantage. The second tenet is that the prosecution and the defense are both entitled to a fair opportunity to address all the material considered by the jury when reaching its verdict. The opportunity is central to the concept of a fair trial in the UK law. Perhaps one of the most notorious examples of misuse of social media during a trial was the case of AG against Frail. Joanna Frail was sentenced to 8 months prison for contempt of court by London's High Court in 2011 for exchanging Facebook messages with the accused in a drug trial while she was serving on a jury. Frail also searched online for information about another defendant while she and other jurors were still deliberating. These activities were undertaken in contravention of a judicial instruction to avoid using the internet during the trial. While use of social media by jurors to communicate with parties to a case appears to be rare, it is not unheard of. More commonly, jurors have used social media to reveal details of ongoing trials or to comment on a trial after its conclusion, which may have effect on any appeals that are lodged. In other instances, jurors have friended each other on Facebook and then posted comments about their jury service or even blogged about the case. In other reported cases, jurors have researched that accused on the internet, spawning the term trial by Google and resulting in contempt of court charges. One thing is clear, there is a wide use of social media in the community. It is mostly true that discussions on social media are less official than traditional press, and the ready access of online information to jurors presents a unique challenge to the justice system in the 21st century. In conclusion, we can see that the internet and social media platforms will affect juries' decision if they do refer to it.
At the end of the topic, how fair is the jury in making decision in criminal process under the English legal system? This actually depends on the mindset of the jury, since they are the ones who gave the verdict rather than the judge. On the question of whether the jurors racially stereotype the defendant, this goes again to the mindset of the jury because the status of the defendant will actually affect the decision-making process of the jury as discussed just now. Here we should say that mindset of jury should be as clean as possible so that the decision would be fair. However, racially stereotyping defendants' majority, the black defendants, is still going on in United Kingdom since there is no error of law and it is also difficult to prove the circumstances. Hence, there should be policy implemented by the Ministry of Justice where the number of white and black jurors should be balanced. There is also a realistic problem is that jurors can be corrupted by outside influences. As jurors are not only paid, only compensated for loss of earnings, then some may be tempted to accept a bribe to vote to acquit the defendant. As jurors are laymen, if the evidence points to one defendant being guilty and the other not, jurors can often be led into thinking that if one should be convicted, so should the other. In other words, guilt by association. However, at the end of the day, stereotyping is indeed part of human nature and it's simply unavoidable, but this does not mean that steps should be taken in order to prevent racial stereotyping. On the issue of improper conduct in the jury room, the question raised that why the jury are still repeating the usual mistake when there is a precedent in the past. It can be argued that there is a growing feeling that certain jurors are more dominant than the other and therefore dominate the jury room. Jurors can be effectively bullied into agreeing with the other dominant juror. But here we should argue that the jurors should have be fair to each other without stating any of each other's status in the community itself. The jurors should know the rules clearly when they are briefed either by the judge or the magistrate clerk, rather than making decisions themselves. On this topic, we discussed just now, the case of Regina and Yang stated that the juror make their decision based on the OIJA board, and is that a proper action? The answer is clearly no, because it is not fair to the legal system as the decision-making process is improper. On the final issue of whether the internet will affect the decision of the jury, it depends how general the information, but the general rule is that internet will most likely affect the mindset and the decision made by the jury. In the case of Regina and Karakaya, it mentioned that the jury actually become biased after seeing the document in the jury room. Hence, it is not fair to the defendant and violating the legal system. In the 21st century nowadays, and information on the internet tend to have very strong impact on the society. The community itself, include the jury, has also strongly relied on the information on the internet, and it is not proper because it will lead to biasness. When bias exists among the juror, the case should be retried and the existing jury should be changed immediately for the purpose of fairness. The system of trial by jury considered as fundamental part in the English legal system and has been successfully used in the society for hundreds of years. Anything that has been remained in such constant use, however such a long period of time, must be deemed to be worthwhile keeping. Although various alternatives have been suggested to the jury system, no one has able to fathom a superior way to decide on the defendant's fate. It has to be said that the system of trial by jury is used to the advantage of the public, and until any other superior alternative is introduced, it will continue to be an asset to the society.